Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we are talking about a recent verdict in the United States of America. It wasn't in New York, but it was a large verdict, and I'm going to wait to tell you how much it was for, and it involved a truck accident case. I know a lot of people have been asking me to do videos about truck accidents. Well, this is a perfect example of how to handle a truck accident. So let me tell you the story of what happened in this case. And the lawyer that handled it is actually one of the founders of the American Truck Accident Attorneys Group that I'm also in, and he's an excellent trial lawyer, and he's written a few books. And one of the books he has written is about almost like Zen, right, and meditation and using the logical core truth in trial. So what was the truth in this case? This involved an F-250. It was a pipeline company truck, and there was an intersection crash. The truck had a stop sign, and so the truck went past the stop sign, and then the plaintiff was a 21-year-old, and he was driving down the road. And because the truck didn't properly stop at the stop sign, didn't take time, didn't look to make sure that they could see that the plaintiff was coming, because of that, the truck slammed, or actually the truck went into the intersection first, and then the plaintiff, coming at speed, crashed into the truck. And unfortunately, the plaintiff was killed. A 21-year-old young man was killed. So it was a very tragic incident. But the argument that the lawyer made was that the driver of the truck didn't look to see if a car was coming from his left. And his view was obstructed because there was like a guardrail there. So he couldn't just see, without stopping. He would have to stop. He would have to inch out. He would have to really take a careful look and see what there is to be seen. And that's actually also in the New York vehicle and traffic law, that a driver, not just a truck driver, all drivers have to look and see what there is to be seen. And so the way that the lawyer framed the case, or the way that he argued it, is that he said, look, this was a company that was doing work here. So the company truck had come to the work site for 8 days, 8 calendar days prior to the date of the crash. I believe the date of the crash was like on the 27th of the month. And so he said, what about on the 19th? On the 19th, the driver had to pull up to that stop sign. He had to stop. He knew the guardrail was obstructing his view. He had to look to make sure it was clear. And then he proceeded. And he did it on the 20th and the 21st and the 22nd. And so for 8 days, he did it the right way. We assume the right way. And then boom, on the 27th, he didn't. What he did was he got to the stop sign, but I guess he just didn't really stop. And then as he got there, he kind of lurched it and he went forward. And so that's what caused the crash. And also they had a black box. That's one of the things that all attorneys should get in trucking crashes, as well as sometimes in just regular motor vehicle crashes. There's like a black box, the electronic control module. So he got that. He worked with an expert. He reviewed the data, and he found that the black box confirmed that there was a harsh or sudden acceleration right before the impact. So then in opening statement, what the lawyer did was he really tried to connect and look each juror in the eye. And he didn't really have a lot of time for jury selection, unfortunately, because this was, I believe, in federal court. So the judge kind of picked the jury. So he did this without voir dire, without jury selection, which I and a lot of other lawyers say is one of the most important things that you have to do, in order to pick a fair jury, in order to get a good verdict. But he had to do it almost without jury selection. But so he looked each juror in the eye, and he used like comfortable repetition, almost like storytelling. He said every day he does this and this, referring to the truck driver. Every day he has to do this and this, and every day he has to stop at the stop sign for those 8 days prior to the crash. So, and then the fact that what the defense argued is that they said, look, our driver had a blocked view, so it wasn't his fault. It was this guardrail he couldn't see. So he kind of embraced that. Instead of arguing with them and saying, no, you didn't, you could have seen, you could have inched out. He didn't really argue with that. He embraced that. He said, yes, they had a blocked view. I admit that. But the truck driver knew it was a blocked view, right? So he just embraced it. Instead of arguing and fighting, he embraced it. And then the other issue that he had to face was that the police found the 21-year-old's phone, and he had Snapchat open. So the defense argued, well, he must have been texting on Snapchat, but the plaintiff's lawyer did a really deep dive. He did a whole investigation, and he found out that the police investigation concluded that there was no evidence that he was using Snapchat. It was just that they found his phone, and a lot of apps were open. Like most people have apps open on their phone. It could be your calendar's open, your messages are open, Facebook could be open, Instagram, Snapchat. Just the fact that an app is open doesn't mean you were using it at the time. There was no evidence that he was using it at the time. If he was using it at the time, there would be some evidence, like he's actively typing or some kind of screen recording. Nothing like that was, so he got that actually excluded because there was no evidence. It was all speculation. And then he said, look, what do you do at a stop sign? You stop, a careful driver stops, you look both ways, you make sure the coast is clear, then you cross. That everyone knows that, right? That's what our duty at stop signs. And he kind of talked about the duty of motorists toward each other. When I'm driving a car, I'm relying on other people. I'm trusting other people. So I'm stopping at the stop sign because I expect other people to stop. If I have a green light, I'm expecting other drivers to stop at the red light. If they don't stop at the red light and they crash into me, well, I'm going to be dead. I'm going to be killed. So you rely on others. It's a sort of trust. And if you betray that trust, right, then it's a betrayal. Then you're one of the 1% of drivers that don't follow the rules. So, and then he did a deposition of the corporate representative from the company. The company was called Crossfire. And he said, look, responsibility includes having an employee safety manual, having safety rules. And are you familiar with this PowerPoint? And the corporate representative, and remember, when you do a corporate representative deposition, the corporate rep, he binds the company. He becomes the voice of the company. So he's not just speaking in his individual capacity as, Joe Blow. He's speaking for the company. So he said, yes, that is our safety manual. I'm familiar with this manual, and it had different things in the manual, and he put it up on the screen, and he said, look, over 35,000 people are killed or die in roadway crashes every year, and 2.44 million people are injured, and over 8,000 people aged 16 to 20 are killed, and 1,600 children under 15 die in road crashes, and the cost of all these injuries is over 230 billion, and the guy just agreed to everything. So then he said, look, well, apparently, this was a deposition, right? So at trial, he said, look, apparently this Crossfire company was safe, right? They have the safety manual. So you know what I'm going to do? I'm going to dismiss them. So he dismissed the company. He didn't even sue them in the trial. He dismissed them because he said, look, they're a safe company. And sometimes, you have to do that. Sometimes people are just greedy, or they want the evidence to be a certain way, but the evidence just isn't that way. What this lawyer was doing was he was really accepting the logical core truth and almost like the universal, right? And that gives him credibility, right? And it gives credibility to the jury. The jury sees this isn't somebody who's a shyster. This is a real, lawyer who's arguing for a real client, and he's doing what's actually true. So this company was safe. He dismissed him from the case. He still had the driver, and the company would still be, the insurance policy would still be responsible for the driver because he was their employee. So it didn't really hurt him, but he said, look at the safety materials, look at the safety manuals, they were there, but this particular driver just chose not to follow them. And, a lot of people say that you have to kind of demonize the defendant, you have to make them evil, right? They're the bad guy. And it's true. I mean, jurors and focus groups will confirm that when there's a bad action by a defendant, that's the reason that jurors allow for money, right? Millions and millions of dollars, because there was a bad action, because the defendants knew it was wrong and they didn't care and they were reckless. They knew that what they were doing could cause harm, but they did it anyway, right? And that's why people give money. But he said another reason jurors would give money is because the value of what was taken, the value of what was lost. And here a family was destroyed. They had this son who they loved. They were actually a conservative family. I believe the son would go hunting. He got a gun when he was a kid from his father. And he actually, it was also another difficult thing for the plaintiff because the venue that he tried it in was kind of like a liberal venue. But these particular people were kind of conservative. They were going out hunting. The kid got a gun when he was little. They had one of those conservative flags, from Southern flags, hanging in their house. But he had to embrace it. He said, look, this is who they are. And he told their truth to the jurors, and the jurors still allowed for a lot of money, millions and millions of dollars. So he basically argued that what the defendant did should not have anything to do with your verdict, right? Because your verdict is not about liability. Your verdict is about damages. And the damages are what this particular individual and what this family lost. I mean, this was a death of a 21-year-old, and this was an immense harm to the overall family. So he said the verdict is really about love and about what was taken from this family. Then the defendants called an expert, and what the defense expert said was that plaintiff was speeding, and he proved that plaintiff, the driver who was killed, was going over 70 miles an hour, and he actually did a reenactment, like a reconstruction, and he had an animation, and he said, look, if he's going 70 miles an hour, so because he's going so fast, that's why when the truck pulled out, he crashed into the truck. If he was going the speed limit, and he did the reenactment and the animation, and he showed, look, if he was going the speed limit, then it would have been a near miss. The truck would have passed, and then he would have gone behind the truck, and he proved that through his technical expert. But the plaintiff's attorney said, look, I don't want to step into your house. I don't want to argue on your playing field or in your ballpark. What I'm going to do is I'm just going to cross-examine your expert. And what's the logical core truth? So he said, this was his cross-examination. He said, at 70 miles an hour, if the truck driver stops and he looks and he doesn't pull out in front of the car, there's no crash. True? And he said, true. And at 55 miles an hour, if the truck driver stops and looks and does not pull out in front of the moving car, there is no crash. True? And at 110 miles an hour, if the truck driver stops and looks, and you get the point, and he said at 40 miles an hour, and even at 20 miles an hour, it doesn't matter. So then he had to say yes, and that was a powerful point, and he destroyed that expert that way. So then, actually, during the trial, the defendant actually filed what's known as a motion in limine, and what they asked the judge to do was they asked the judge to not allow the plaintiff's attorney to say certain things. And what they actually asked the plaintiff's attorney not to be able to say is that not to be able to tell the jury, you should hold the defendant responsible because they won't take responsibility. And it's kind of like a silly argument because they're not taking responsibility, right? They're defending the case, but yet they're making this argument. But I think he won that motion, and that motion was denied. And then in the defendant's closing argument, in the summation, the defendant actually said something that is not allowed. And they said, can you imagine, talking to the jury, can you imagine this truck driver being your brother or your son? Because this truck driver suffered a lot, right? He was fired. He was put through all this. He has to go through a trial. He has this worry in his heart that someone died because of his actions. So he's already paid his price. He's already gone through all this. Can you imagine this was your brother or your son? And that's not allowed because that's a golden rule violation, right? You can't put the jury in the position of a party, meaning a plaintiff or a defendant. Just like a plaintiff's attorney cannot say, well, what if your son was killed? Can you imagine that? Wouldn't that be worth, a lot of money? How much would you want if your son was killed? So then give us the same amount. That's not allowed. That's a golden rule violation. But even though the defendant did this, the plaintiff's attorney did not object. He kind of just let them do it because that was a strategy. He thought, okay, you guys want to do that? Go ahead and do that. And then when he cross-examined, when he did his cross-examination of the defendant, this was earlier in the trial, he actually said, I like you, Mr. G, whatever the defendant's name was, I like you. Thank you for taking responsibility. And let's talk about what you are admitting responsibility for. What does responsibility mean? And he kind of went through it, that I did it. He admits that he did it. He didn't look. He pulled out. He admits that, he was wrong. And also, doesn't responsibility have a component not just of saying I'm sorry, but also of making it right, meaning paying for all the harms and losses? So that was a very smart thing that he did. And then finally, in the plaintiff's closing argument, he actually talked to the truck driver, the plaintiff's attorney, and he said, look, Mr. Truck Driver, my client's mom and dad, so if the client is dead, my client's mom and dad, his parents, they forgive you. We're not asking, but we're still, we forgive you for what happened, but we're still going to ask the jury to hold you accountable because you were not reasonably careful, and the evidence has shown that. And then they said, but don't make, and he's talking again to the jury, and he says, but don't make this a double tragedy, meaning get on with your life. Let the truck driver get on with his life. We don't want to punish him anymore. We don't want to, put him in jail. We don't, just let him get on with his life. He shouldn't have to suffer anymore. He shouldn't be depressed or, get on with your life. For example, the kid who was killed, the 21-year-old, loved nature. He loved to fish. He loved to hunt. He would, go out, hunt and fish and hike and be in nature. So he said, you like nature too. There was some evidence that the truck driver liked nature. So he said, go out and do that. Go out and enjoy your life. So then the jury had to render their verdict. So let me tell you the verdict. The verdict in this case was actually $18.5 million. So you see, you don't have to necessarily demonize the defendant. You can admit certain things. Like he said, look, that's your defense. I admit to that defense. And you don't necessarily have to argue with the defense on every point. He was a really smart lawyer. He went to the logical core truth. He talked about universals, and he got a great result, $18.5 million. Okay, I hope this was helpful. Let us know what you think. We are here for you. Please like and subscribe to our channel. And if you have any questions, text me. It's 347-566-9595. I've been doing a lot of consultations with people, whether it's in New York, I could help you myself. If it's somewhere else, I could have a lawyer like this or another lawyer from the American Truck Accident Attorneys, perhaps give you a consult, handle your case. That's what we're all about. We're all about helping serious injury victims and their families. Okay, have a great day, everyone, and we are here for you. Bye-bye.